And you say, well, why not? Well, the reason is they operate under different rules of engagement than your police do. In Afghanistan or Iraq or in any kind of war theater, you don't have warrants, you don't have Miranda rights, you don't get due process in war. But at home, you do. That's why it's important that we get folks to acknowledge that this is not a battlefield. America's not a battlefield. It's a place where you have constitutional rights and have for hundreds of years. But the Posse Comitatus Act after the Civil War regulated and prohibited the military from acting as a police or taking a police role on U.S. soil. Proponents say that the high-resolution cameras, heat sensors, and sophisticated radar on the border protection drones, and this is the other point, these drones were legislated to be used on the border, and you can argue that there's a federal role for monitoring our borders for national defense and other reasons. But now they're loaning them out to local law enforcement, and law enforcement's also buying drones directly. So they have high-resolution cameras, heat sensors, and sophisticated radar on the border protection drones that can help track criminal activity in the United States, just as the CIA uses Predators and other drones to spy on militants in Pakistan, nuclear sites in Iran, and other targets around the globe. For decades, U.S. courts have allowed law enforcement to conduct aerial surveillance without a warrant. This is that sort of open spaces doctrine. I'm not saying it makes it right, but the government's been doing it for decades. Some of the courts apparently have ruled that what a person does in the open, even behind a backyard fence, can be seen from a passing airplane and is not protected by privacy laws. Well, you know, I don't think I agree with that. I mean, if you're swimming in your pool in your backyard or you're in your hot tub in your backyard, just because we have the technology to be able to see you in your hot tub, does that really mean they've got a right to look at what you're doing in your backyard? So I don't really accept that. And I think it's been abused and something that really we should be fighting against, you know, this surveillance state. Advocates say Predators are simply more effective than other planes. Flying out of earshot and out of sight, a Predator B can watch a target for 20 hours nonstop, far longer than any police helicopter or manned aircraft. What I would say there is it seems like that might be somewhat analogous to the GPS case, because the Supreme Court ruled that you can't just tag people's car and just watch them constantly waiting to see if they break any laws. And so I would think the same for a Predator, that you just stake them out, watch, and eventually you'll get somebody breaking the speed limit or running a stop sign. I don't think that's what was really intended. Howard Safir says, I am for the use of drones. He's the former head of operations of the U.S. Marshal Service and former New York City Police Commissioner. He said drones could help police in manhunts, hostage situations, and other difficult cases. I agree completely. If someone's being held in harm's way, if someone's being held and threatened, absolutely, drones are a great idea. So it's not that I'm opposed to the technology. I am not particularly excited about them hovering outside your window, looking over your shoulder at what magazines you read, whether you're reading any free market magazines that might be offensive to government officials. So I think that we don't want people looking into your activities in your house without a warrant. But I think in situations where people have already broken the law and there's lethal force being exposed and there are people that are in danger, you know, why wouldn't we want to use a drone versus a policeman to save the life of a policeman going into a difficult situation? So I think those probably will come to fruition, and that doesn't really bother me. And in some ways, it's a little bit analogous to the situation we're talking about with drone strikes by the military in the United States. It's not so much that anybody's really opposed to using a drone to shoot down a plane that's flying in to attack us, or people are flying into a building to knock a building down, or flying into the Capitol. Nobody's really opposed to using a drone when there's a lethal imminent force. The problem is it's gotten so convoluted because, you know, the president said imminent threat doesn't have to be immediate, you know, and so that's the kind of thing we're concerned about. We're not concerned really about, you know, a threat, an imminent or lethal threat where someone responds. What we're concerned about is a drone strike against a non-combatant. Seems like it ought to be an easy question for the president. Couldn't he at least just respond and say, you know what, I've always believed this, I just forgot to mention it, and we weren't very clear in the way we expressed it, but obviously we would never use a drone against a non-combatant. He needs to say that, though, because the drones overseas are being used against non-combatants, and we need to know what the rules are going to be. This is a long, drawn-out day, but it's to try to get some answers. It's to try to shame the president into doing the right thing. I think he knows what the right thing is. I think the president, part of him would like to do the right thing. But I think there's a certain stubbornness there, too. I think there's a certain belief that he's the president, and presidents have all this power, and he doesn't want to give any of that power up. And I think some of that you see, with Republicans and Democrats, frankly, that people leave the legislative branch. When they get into the White House, they think, I'm a good person. I would never use the power wrongly, so why would it be wrong if I got more power? Why would it be wrong if I said, I'm going to use the Fifth Amendment, people will get due process, except for sometimes when I just think they're really bad people. And then I won't use the Fifth Amendment. We won't get due process. Now, privacy advocates say that drones help police snoop on citizens in ways that push current law to the breaking point. Anytime you have a tool like that in your hands of law enforcement, it makes it easier to do surveillance. They'll do more of it, says Ryan Kalo, Director of Privacy and Robotics at the Standard Law School's Center for Internet and Society. This could be a time when people are uncomfortable and they want to place limits on that technology. It could make us question the doctrines that you do not have privacy in public. I think that's a good point. Maybe we will question some of the things we've said before about open spaces now that we can crisscross every minute inch of your open spaces. You have to imagine that we now have drones that weigh less than an ounce. So we're not even talking about the pictures of you coming down. And some of us, after a while, really don't want pictures of us in our bathing suit, whether it's 2 miles up or whether it's, from 5 feet in front of us. And so I can't imagine that we would eventually rule that a drone could swoop down and be 10 feet over your fence. But what's the question going to be? Can they be 10 feet over your fence or 2,000 feet in the air and still snoop on you without any kind of probable cause? Do we want to live in a police state is basically what the question is. Do you want to live in a surveillance state? But it's going to take people who stand up and say enough's enough, that we're just not going to do this, instead of everybody being like a herd of lemmings and just going off the cliff saying, lead me, take care of me. We have to ask the question, that Franklin asked. Are you going to trade your liberty for security? Are you so fearful? Are you so afraid that you're willing to trade your liberty for security? And that's sort of the underlying question to this entire debate. In the Los Angeles Times article, they continue, this could be a time when people are uncomfortable and they want to place limits on that technology. It could make us question the doctrine that you do not have privacy in public. This is from a June 13th article, 2012, in Wired magazine by Lorenzo Franceschi Bicchieri. We like to think of the drone war as something far away, fought in the deserts of Yemen or the mountains of Afghanistan. But we now know it's closer than we thought. There are 64 drone bases on American soil. That includes 12 locations housing Predator and Reaper unmanned aerial vehicles, which can be armed. Public Intelligence, a nonprofit that advocates for free access to information, released a map, which probably is not a very good idea, to tell you the truth, the map of where our drone bases are in the United States, assembled from military sources, especially little known since June 2011. The possibility of military drones, as well as those controlled by police departments and universities flying over American skies, have raised concerns among privacy activists. The other thing that should concern everybody, and probably people saw this, is they had some university students seeing if they could commandeer a drone. So they had a drone fly over, and a guy that didn't know the frequency, all of a sudden within 2 minutes is commandeering the drone. And there's questions whether that's what happened in Iran or whether the thing landed accidentally. I don't really know the answer to that. But I think it's of concern that the drones could be commandeered and used by other people. It's also of concern that ultimately our enemies are going to have these drones too. And so while war is a messy thing and there are a lot of imperfections to war, I think the way we act in war should be the way we ultimately want to be treated in war. And it's easier said than done, and I don't think an easy doctrine, but it's something that we should aspire to. The possibility of military drones, as well as those controlled by police departments and universities flying over American skies, has raised concerns among privacy activists. The American Civil Liberties Union explained in its December report that the machines potentially could be used to spy on American citizens. The drone's presence in our skies threatened to eradicate existing practical limits on aerial monitoring. I wouldn't mind having some articles that are more for civil liberties, less. The drone's presence in our skies threatens to eradicate existing practical limits on aerial monitoring and allowing for pervasive surveillance, police fishing expeditions, and abusive use of these tools in a way that would eventually eliminate the privacy Americans have traditionally enjoyed in their movements and activities. I've told people that when I first read 1984, I was bothered by it, and everybody's bothered by, Big Brother being able to have these two-way televisions in your house, and they see everything you do, and you can't escape Big Brother. But part of the consolation I had, and part of the feeling I had was, well, they can't do this. The technology doesn't exist. When I was a kid, it didn't exist. It's amazing, though, to think that Orwell writes this in 1949, before any of this technology was. We were getting closer in the 70s when I was a kid, and now we're there, though. The technology is there. So while technology is not an enemy, and technology is not something we can or should ban, technology makes your privacy more important. It makes the defense of your privacy something that needs to be guarded more jealously, because your government now does have the technology to see your every movement, to monitor your every move. So do your enemies, for that matter. So you can imagine you don't want the police GPS tagging you. You probably don't want your political opponents tagging your car either. So there have to be some protections of privacy. The issue and discussion of privacy has been one that conservatives and people on the right haven't always been as unified. Now, libertarians on the right have been better with these issues, and some conservatives have as well. But the question has always been, do you have a right to privacy? I've always said, sure, you have a right to privacy. I can't imagine why you wouldn't have a right to privacy. Now, some on the conservative side say, well, you don't really have a right to privacy. It's not, nobody talked about it in the Constitution, so you don't necessarily have a right to privacy. I kind of disagree, because I think what's talked about in the Constitution are the freedoms you gave up or you agreed to have limited. The freedoms that you didn't agree to have limited are unnamed. They're unenumerated, and the 9th and 10th Amendment says they're to be left to the states and people. The things in the 9th and 10th Amendment, what it says is that there's a plethora of rights. There's an unlimited amount of rights, and they're yours. They're to stay with you unless the government explicitly takes these rights away from you. And so what the conclusion I have with the right to privacy is that I think you do have a right to privacy. And I think you have a right to private property. Now, private property isn't listed in the Constitution either. But I think all of our founding fathers believed in private property, and some of them talked about actually putting the word in there. But I think some of them liked more the idea, instead of life, liberty, and property, they liked life, liberty, and pursuit of happiness. And I think it has a more noble ring to it, because it's not talking about the property to lead, but pursuit of happiness does involve the pursuit of gaining of things that you will own. One of the things about our government and about the rule of law, and one of the things really that frankly I think a lot of people don't think about, but that makes us an incredibly prosperous nation, is the certainty of the law. And by that what I mean is that the certainty of ownership. And this gets to sort of the idea of why not only do we want these rights for the civil protection, so we can't be incarcerated or accused of a crime falsely without being able to defend ourselves, we also want the rule of law to be consistent for everyone and not mutable. We don't want it to be arbitrary. We don't want the whims of any politician or any executive to be able to decide what the law is. And this isn't the first time that I've had some disagreement with the president on this. When we had some of the bankruptcies, when the car companies were going bankrupt, I believe it was with the Chrysler bankruptcy, that as things went through, there were people who were creditors and they owned part of the company. I learned this firsthand because I actually had some Fruit of the Loom stock. When Fruit of the Loom went bankrupt, I thought, well, I'll get something, right? They'll be bought out, and I'll get some money when they're bought out. I didn't get anything. I was an unsecured creditor. Well, apparently in the Chrysler thing, so were the labor unions, and usually what happens is a company unfortunately goes bankrupt, all those contracts would be renegotiated, and really then the car companies could become competitive. They could become like Toyota or other successful companies that are non-unionized, and they might have become successful again. But instead, we took the actual bankruptcy law and we turned it on its head. When we do this, and when we bail out banks and things and change the rules in midpoint, it changes what investors do. And it changes that certainty that investors need, either in banks or in car companies. Pension plans invest in a lot of these things. And so a lot of people think, oh, well, the president, had preference for the union because he liked the union. Well, that's fine, but teachers are in a union too, and they had a pension plan, and they own Chrysler stock, and they got ripped off because he changed the law and gave the money to the auto workers union, but he took it from somebody else. The problem is you need those pension funds, some of which are regular working folks. Firemen have them, police have them, teachers have them. It's one of the things that wasn't fully explained, I think, in the Romney election. He got so much grief for running these funds, but a lot of the people who became successful along with him and who made money were just average, ordinary citizens that are teachers, firemen, and policemen. Their pension plan is there was there in Bain Capital. And I think that was never fully explained. But my point is with the rule of law is that certainty is what creates our wealth in our country. One of the reasons it's hard for Africa to get ahead, Africa has great resources, diamonds and minerals. One of the big reasons they don't get ahead is because there's corruption in their government. Some of that corruption we aid and abet because we give foreign aid directly to corrupt governments who steal it. Mubarak was one of the richest men in the world, probably worth between 5 and 10 billion, maybe 15, 20 billion. We gave him 60 billion, so I guess we should be thankful he only stole, a third of it. Mobutu in Central Africa stole billions. There was no running water, no electricity. He and the soldiers around him lived high off the hog, and they took our money and stole it as well. But the problem is not only do you have the kleptocracy and the stealing of foreign aid, but then you don't have the certainty of your property. A lot of capital formation in our country is based on your home loans. It used to be before the housing market went south, but it still is. It's where a lot of capital comes from, particularly for average ordinary citizens, is borrowing against their house. If you don't have that certainty of the law, it's a problem. So what we're talking about today is more certainty of your liberty from unfair prosecution or unfair arrest or unfair death, ultimately, from a drone, which takes consistency of law, which takes that the Constitution will be adhered to, and it will be adhered to consistently and not in an arbitrary fashion. So it's important not only for your civil liberties, it's also important for your private property as well to have a rule of law. People talk about a rule of law, and they talk about it all the time, but I don't think it fully gets through to everybody exactly what a rule of law means and how important it is. Hayek wrote that nothing more clearly distinguishes an arbitrary society from the rule of law, or arbitrary society from a stable society, than the rule of law. He said that the rule of law is what gives that certainty to the marketplace. So it's not enough just to have freedom. You can have complete and random anarchic freedom, and you may well not get prosperity if you don't have a law that stabilizes things. You have to have a police force and a judiciary that enforces contracts. So that's a lot of what goes on in the developing worlds that they don't have. They've got kleptocracy, which we aid and abet by giving them money and giving it to thieves because the thieves are our friends, not somebody else's friends. But then they also have this instability by not having a rule of law. The presence of drones in our skies, threatens to eradicate existing practical limits on monitoring. This comes from the article in Wired by Lorenzo Franceschi Bicchieri. As Danger Room reported last month, even military drones, which are prohibited from spying on Americans, may accidentally conduct surveillance and keep the data for months afterwards while they figure out what to do with it. The material they collect without a warrant, as scholar Stephen Aftergood revealed, could then be used to open an investigation. The Posse Comitatus Act prohibits the U.S. military from operating on American soil. So once again, if we go back to asking the president this question, can you do military strikes on Americans on American soil? An easy answer is I will obey the law. The law says he can't do it. And yet he indicates that he's going to have different rules inside America than outside America for his drone strikes, which implies that he thinks he can do it. The Posse Comitatus Act expressly forbids the military from operating in the United States. So if he's going to kill Americans in America, it will either be in defiance of the Posse Comitatus Act, or he's going to have to arm the FBI with drones to kill people. The problem is, I think once he gets into the FBI, the ludicrous nature of what he's asserting will really be, I think, paramount. I can't imagine that he can argue at that point that we're not going to obey the Bill of Rights with the FBI because we already do with the FBI. So many of the answers are pretty simple here and pretty easy, and I just can't imagine why he's resisting doing this. There's a new map that comes out almost 2 months after the Electronic Frontier Foundation revealed another one, this time of public agencies, including police departments and universities that have a permit issued by the Federal Aviation Agency to use drones in American airspace. It goes to show you how entrenched drones already are, said Trevor Tim, an EFF activist, when asked about the new map. It's clear that the drone industry is expanding rapidly, and this map is just another example of that. And if people are worried about military technology coming back and being sold in the U.S., this is just another example of how drone technology is probably going to proliferate in the U.S. very soon. This is another article from February of 2013. This is in Wired. It's called Domestic Drone Industry Prepares for Big Battle with Regulators. For a day, a sandy-haired Virginian named Jeremy Novara was the hero of the nascent domestic drone industry. Novara went to the microphone at a ballroom in a Ritz-Carlton outside D.C. and did something many in his business want to do: tenaciously challenged the drone regulators at the FAA to loosen restrictions on unmanned planes over the United States. Judging from the reaction he received and from the stated intentions of the drone advocates who convened the forum, the domestic drone industry expects to do a lot more of that in the next coming months. There's been a lot of hype around unmanned drones becoming a fixture over U.S. airspace. You may have seen just 2 days ago, I think, pilot coming into New York City saw one on the way down, and I saw the report, I think yesterday, saying they're still asking whose drone it was. You would think certainly we'd have found out in 24 hours. I would think for certain it would probably be a government drone, but it's a little worrisome that they're seeing drones that they don't know who's flying them or where they are as far as getting in the way of our commercial airliners. There's been a lot of hype about drones becoming fixtures over U.S. airspace, both for law enforcement use and for operations by businesses as varied as farmers and filmmakers. This sort of leads to another point, that it's not the technology that we're opposed to. There's going to be all kinds of private uses for drones. There have to be some rules where they're flown so they don't get in the way of airplanes. But I would think farmers and ranchers might want to use drones to look at their, count their cattle or their sheep. I don't know if you do that or not. But, I mean, there's going to be private uses for these drones that won't be objectionable. All of these have big implications, though, for traditional conceptions of privacy, as unmanned planes can loiter over people's backyards and snap pictures for far longer than piloted aircraft. The government is anticipating that drone makers would generate a windfall of cash as drones move from the military to the civilian role. Jim Williams of the Federal Aviation Administration told a conclave at the Drone Manufacturers Conference that the potential market for government and commercial drones could generate nearly $90 billion in economic activity. But there is an obstacle, they say, the FAA. The FAA has been reluctant to grant licenses out of fear that the drones, which maneuver poorly, have an alarming crash rate, and are spoofable, don't have the sensing capacity to spot approaching aircraft, which could complicate and endanger U.S. airspace. The FAA has been criticized some by, there's a group called the Electronic Frontier Foundation for not being transparent about its licenses. And they've filed Freedom of Information Act because they'd like to know whether the intentions of those putting the drones up is benign or whether it involves some kind of surveillance. I think ultimately we talk a lot about the government spying on us, but I think there's great potential for your competitors, your enemies, and other people to spy on you with drones, particularly as they become cheaper. Those issues will be complicated. I think one way to sort of rectify or give an answer to those is I think your property from where it starts on the ground up is yours. People can fly over it, but I don't think they should be able to snoop and look down in it. I think probably private or public looking down in your property. That'll be something, though, that the courts will continue to have to work out. There was a push last year by Congress and the Obama administration directing the FAA to fully integrate unmanned aircraft into American skies. It hasn't been nearly enough for the drone makers. The FAA is months late in designating 6 test sites for drones around the country. Just try to find me that article. The question's, when the test site selection will begin. I'm sure that all of you are asking that now, says Williams, the head of the FAA's drone division. Drone makers are also frustrated by the logic of existing regulations. Currently, a drone weighing under 55 pounds, flying 400 feet within an operator's line of sight and away from an airport is considered a model airplane and cleared to fly without a license. That is, if it's not engaging in any for-profit activity. Sort of. A farmer can be a modeler if they operate their aircraft as a hobby or for recreational purposes. Enter Novara, a 31-year-old who owns a small drone business in Falls Church, Virginia, called Vanilla Aircraft. If a farmer who hopefully is profit-minded can fly as a hobbyist in unmanned aircraft, Novara challenged Williams, why can't I, as the owner of an unmanned aircraft company, fly as a hobbyist my own unmanned aircraft over property that I own? The guidelines for this were that any commercial intent is prohibited, but the bottom line is there's going to be a lot of things that we're going to enter into with private drones, but opposition to the technology, either for military purposes or for private purposes, is not something that we are going after what we're talking about is whether or not your privacy will be respected and whether your constitutional rights will be protected. This is a new article from today by Connor Friedersdorf. It's called Killing Americans on U.S. Soil, Eric Holder's Evasive, Manipulative Letter. On December 7, 1941, Japanese warplanes bombed the U.S. naval base at Pearl Harbor, Hawaii. 6 decades later, al-Qaeda terrorists flew hijacked airplanes into the World Trade Center and the Pentagon. Neither President Roosevelt nor President Bush targeted and killed Americans on U.S. soil in the aftermath of these attacks. Doing so wouldn't have made any sense. How strange, then, that Attorney General Eric Holder invoked these very attacks in a letter confirming that President Obama believes there are circumstances in which he could order Americans targeted and killed on U.S. soil. Kind of strange. The things that he gives as justification are things in which we didn't kill Americans. It's possible, I suppose, to imagine, these are Eric Holder's words now, it's possible, I suppose, to imagine an extraordinary circumstance in which it would be necessary and appropriate under the Constitution and applicable laws for the President to authorize the military to use lethal force within the territory of the United States, he wrote. For example, the President could conceivably have no choice but to authorize the military to use force, if necessary, to protect the homeland in the circumstances of a catastrophic attack like what happened in 1941 and again on 9/11. This very scenario to be guarded against is a president using the pretext of a terrorist attack to seize extraordinary powers. Isn't that among the most likely scenarios for the United States turning into an authoritarian security state? To be sure, if Americans are at the controls of fighter jets en route to Hawaii, of course Obama could order that they be fired upon. If Americans hijacked a plane, of course it would be permissible to kill them before they could crash it into a building. But those are not the sort of targeted killings we're talking about. What we're talking about is killing people not engaged in combat because you suspect them of being a terrorist. If you read to the end of Holder's letter, to the passage where he said, and this is Friedersdorf again, if you read to the end of Holder's letter, to the passage where he says, were such an emergency to arise, I would examine the particular facts and circumstances before advising the President on the scope of his authority. It becomes clear that despite invoking Pearl Harbor and 9/11, even he isn't envisioning a response to an attack in process, which would have to happen immediately. So what does he envision? If he can see that, for example, is necessary to explain, he ought to give us a clarifying example rather than a nonsensical one that seems to name-check events for their emotional resonance more than for their aptness to the issue. Elsewhere in his letter, Holder writes that the U.S. government has not carried out drone strikes in the United States and has no intention of doing so. As a policy matter, moreover, we reject the use of military force where well-established law enforcement authorities in the country provide the best means for incapacitating a terrorist threat. Interesting, they reject it as a policy matter, but aren't willing to reject military force in the United States as a legal matter. This is a good distinction. Even in instances where law enforcement would better incapacitate the threat. For the Obama administration, conceding that the executive branch is legally forbidden to do certain things is verboten. So it is kind of interesting. They're willing, when they are willing to admit to any kind of limitations on their power, they say policy-wise they might be limited, but they're not willing to say legally they are limited. And this is a problem of not just this administration, but the previous one, of thinking that any kind of inch that they give to another branch of government, that they will be losing some of their power, and they're unwilling to do it. Friedersdorf goes on to say that For the Obama administration, conceding that the executive branch is legally forbidden to do certain things is verboten, despite the fact that an unchecked executive is much more dangerous than the possibility of a future president failing to do enough to fight back against an actual attack on the homeland. Any thinking person can see that Holder's letter is non-responsive, evasive, and deliberately manipulative in its sly reassurances, right down to the rhetorically powerful but substantively nonsensical invocation of 9/11. Being more subtle about it than Rudy Giuliani doesn't make it right. To credulously accept this sort of response on an issue as important as this one is behavior unfit for any citizen of a free country, where safeguarding the rule of law is civic responsibility. The time to discuss the appropriate scope of the president's authority is now. I know many would rather defer this, they'd rather do this at another time. But the thing is it is now. We've brought the issue up. We spent a lot of time on this issue. Why not have a discussion? Instead of putting me off and saying, oh, we'll have a committee hearing on it. Oh, sorry, you're not on that committee, but we're going to have a committee hearing on this at a later date. It'll never be discussed. Nothing ever happens around here. I mean, they promise you stuff. They say we're going to take care of it, but it never happens, and I think it never will. The time to discuss the appropriate scope of the president's authority, this is Friedersdorf again, the time to discuss the appropriate scope of the president's authority is now, not in the aftermath of a catastrophic attack on the nation, as Holder suggests. The fact that he disagrees speaks volumes about Team Obama's reckless short-sightedness. This is another article from Wired. This is from today also. This is by Spencer Ackerman. The Obama administration calls it targeted killing. Steven Seagal would call it getting marked for death. It's the practice of singling out an individual linked to a terrorist group for killing, and it's played out hundreds of times in the 9/11 era, including more recently against U.S. citizens like al-Qaeda's YouTube preacher Anwar al-Awlaki. The Obama team has said next to nothing about how it works or what laws restrict it until Monday. Attorney General Eric Holder explained that the administration's reasoning for killing American citizens overseas, and only overseas, with drone strikes and other means during a Monday speech at Northwestern University. Holder claimed that the government can kill a U.S. citizen who is a senior operational leader of al-Qaeda or associated forces, provided the government unilaterally determines that the citizen poses an imminent threat of violent attack. Once again, a little bit of a problem on the imminent doctrine is that imminent doesn't have to mean immediate. He can't be captured, and the law of war principles, like the use of proportional force and the minimization of collateral damage. The reason why some of this is important, even though he's talking about overseas now, not what we're trying to talk about here, is that since we haven't been given sort of the parameters for how they will kill Americans in America, we can only assume that they'll work with the parameters they have overseas. The whole idea that an imminent threat's not immediate is problematic no matter where that doctrine is used. The idea that the law of war principles, I think proportional force is a good idea, as far as, trying to restrain how much force we use. But there's other things within the law of war that we need to be concerned about, that things that happen in war aren't quite the same kind of standard that we would have in the United States. Ackerman goes on and he says, this is an indicator of our times. This is actually Holder. This is an indicator of our times, not a departure from our laws and our values. The debate over killing al-Awlaki, whom Holder barely discussed, began long before a Hellfire missile fired from a drone killed him and fellow propagandist Samir Khan in September. Al-Awlaki's father sued the Obama administration in 2010 to compel it to reveal its legal rationale for the long-telegraphed strike. The administration refused with a judge's support. For months after al-Awlaki's killing, the government never disclosed any evidence supporting its decision that al-Awlaki posed an imminent danger to Americans, beyond his rhetoric of incitement. But during the February sentencing of the Unabomber, or the underwear bomber, the government put forward a court ruling or a court filing claiming that al-Awlaki worked intimately with convicted would-be Umar Farouk Abdullah Muttalab, who was the underwear bomber, to blow up Northwest Airlines. Holder referred to that connection in his speech. Several legal scholars have wondered why the U.S. didn't have to provide al-Awlaki with due process of law before killing him, as stipulated under the Fifth Amendment. Holder contended that the U.S. actually did, even if no judge ever heard the case. This is sort of an interesting point, and I'm not really making an opinion on whether or not the Fifth Amendment applies to al-Awlaki overseas. I think a lot of that's complicated and not necessarily certain whether you can apply the Constitution to people outside the United States, or whether an entity within the United States should obey the Constitution on people outside the United States. The bottom line is, in war, you're not going to really get due process, and you're not going to get Miranda rights if you're fighting in battle. It's a little bit more debatable when you're not. The point is, though, that they're saying they're applying the Fifth Amendment sort of in private to al-Awlaki. The question is if this is the standard that's going to be used in the United States, it's not going to be the actual use of the Fifth Amendment, which means a court and a jury. It's going to be the pretend use that's done behind closed doors. I'm not so sure you can have the Fifth Amendment, that doesn't involve a courtroom. I don't know. I just don't understand, grand jury indictment, due process, not to be deprived of life and liberty. I don't know how it happens in private, but that's the way they're administering the Fifth Amendment in private, and they're using their discretion as to when to administer the Fifth Amendment. But I just don't know how that's going to work. I also don't think that's appropriate for U.S. citizens. So really, other than the president asking and answering a question as to whether non-combatants will be killed in America, he needs to ask whether he's going to, before he kills them, is he going to use the Fifth Amendment in private in the Oval Office, or is the Fifth Amendment going to be public? If it's public, I don't know how you kill somebody. If you really are going to get some kind of due process, you'd have to get tried in a court. I'm not sure how this would go forward. This is an additional quote from Holder from the same speech. The Constitution's guarantee of due process is ironclad, and it is essential. But, as a recent court decision makes clear, it does not require judicial approval before the president may use force abroad against a senior operational leader of a foreign terrorist organization with which the United States is at war, even if that individual happens to be a U.S. citizen. Well, that's kind of confusing. I mean, if that's going to be the standard here, I'd be quite concerned. The standard over there, I think there's arguments on both sides of, but the standard over here, I just can't imagine that this is the standard we're going to use. Because basically he's saying the Constitution applies unless we think it doesn't apply, and they've decided that it doesn't apply. But then he says, as long as we're at war. Well, who are we at war with? You have to decide. We're at war basically with anybody who doesn't like us around the world, and I'm not sure if there's ever an end to that. I think there are problems overseas, but particularly the problem is, and I think the problem at hand that we're trying to get to the root of is that, is this the standard? If you're using this standard overseas, are you going to use the standard here? That basically the Fifth Amendment applies when we think it applies, and it doesn't apply when we don't think it applies. Now this is Ackerman at this point from Wired again. Holder did not explain why Al-Awlaqi's 16-year-old son, whom a missile strike killed 2 weeks after his death, was a lawful target. Holder did not explain how a missile strike represents due process or what the standards for due process the government must meet when killing a U.S. citizen abroad. Holder did not explain why the government can only target U.S. citizens suspected of terrorism for death overseas and not necessarily domestically. The thing to be, like I say, a lot of these things overseas, you can debate and try to decide whether or not, this is a war zone or not a war zone, but they obviously don't apply in the United States. The most troubling thing about Al-Awlaqi, the 16-year-old son of Al-Awlaqi, is the president's spokesman's response to this. The flippant nature of it and I think, irresponsible, nature for him to have said, well, he should have chosen more responsible parents. I think if that's the standard we're going to have for killing Americans on American soil, that we're going to kill people who, don't have responsible parents, we've set the bar pretty low for our killing program. I think Al-Awlaqi was killed. I don't know. I've not seen the classified information. I think the son was killed probably when they either targeted someone else or they did what they're calling these signature strikes, where they don't know who they're killing necessarily. They just think they're bad people because they came from a meeting of other bad people. The decision to kill an American, Holder said, is among the gravest that government leaders can face. Targeted killing is not assassination, he argues, because assassinations are unlawful killings. Among the few external limitations of the government's war power that Holder mentioned were the approval of local government where the strikes occur, which must have pleased reluctant, unsteady U.S. allies in Pakistan and Yemen. So I guess he's saying that, interesting thing, and probably Pakistan has approved of most of the drone killings, but Pakistan wants to kibitz and say, oh, no, we haven't. They're doing it against our will, but my guess is they've been told. Some members of Congress don't consider this to be a sufficient safeguard. The government should explain exactly how much evidence the president needs in order to decide that a particular American is part of a terrorist group, says Senator Ron Wyden, an Oregon Democrat who sits on the Senate's Intelligence Committee. This is a further quote from Senator Wyden. It's also unclear to me whether the individual Americans must be given the opportunity to surrender before lethal force is used against them. And I'm particularly concerned that the geographic boundaries of this authority have not been clearly laid out. The point on the geographic boundaries is a pretty important point, because, see, this is one of the concerning things about what they maintain. They say there are no geographic limitations. They say they get the authority for war everywhere around the world as well as war here, because they say there are no geographic limitations to the use of authorization of force when we went to war in Afghanistan. I think people who voted for that, and I would have voted to go to war in Afghanistan, but people who voted for that, I think, thought we were going to Afghanistan to fight the people who got us on 9/11. I don't think they thought when they voted for that resolution that it meant that we could have war in the United States under that resolution, and that the standard would be one of the laws of war or one of martial law within the United States. I don't think anybody voting on it had that conclusion. But that's the real problem, is that people are saying, including the administration, is saying no geographic limitations, and essentially there's no temporal limitations. So we have a perpetual war without any geographic limitations, which now they want to apply war principles to killing in the United States. This is Ackerman going on, and he says, based on what I've heard so far, I can't tell whether... this is still Senator Wyden. Based on what I've heard so far, I can't tell whether or not the Justice Department's legal arguments would allow the president to order intelligence agencies to kill an American inside the United States. So he's unclear about it, and he's seen a lot more information than I have, because he's on the Intelligence Committee and sees secure and classified information, and he's unsure of it. And so that makes me think that nobody in the Senate or the Congress really knows whether or not they're asserting whether they can kill Americans on American soil. Mary Ellen O'Connell, the vice president of the American Society of International Law, found Holder's legal rationale flimsy. This is her quote. First, Holder restates the renamed Global War on Terror, which Obama himself condemned. Then he tries the UN Charter Article 51, but does not include the whole article. It says member states of the UN have an inherent right of self-defense if an armed attack occurs. Article 51 does not provide a legal green light for targeted killing. O'Connell said in an email. Finally, he adds, the argument that the U.S. may use force against states that are unable or unwilling to attack. This argument has no basis in international law. It simply does not exist. So regardless of how carefully you target under the law of armed conflict, there is no right in the first instance to target at all. Mr. President, without yielding the floor, I'd like to entertain a question from the senator from Utah.
Senator Paul, you recently sent a letter. Go on for a little. Okay. Senator Paul recently sent a letter requesting some information from the Obama administration with regard to these issues relating to drone strikes. It is significant that on March 4th, 2013, just a couple of days ago, Senator Paul received back a letter from the administration that reads as follows. It says, Dear Senator Paul, this is signed by Attorney General Eric Holder, Jr. On February 20th, 2013, you wrote to John Brennan requesting additional information concerning the administration's views about whether the president has the power to authorize lethal force, such as a drone strike, against a U.S. citizen on U.S. soil and without a trial. As members of this administration have previously indicated, the U.S. government has not carried out drone strikes in the United States and has no intention of doing so. As a policy matter, moreover, we reject the use of military force where well-established law enforcement authorities in this country provide the best means for incapacitating a terrorist threat. We have a long history of using the criminal justice system to incapacitate individuals located in our country who pose a threat to the United States and its interests abroad. Hundreds of individuals have been arrested and convicted of terrorism-related offenses in our federal courts. The question you have posed is therefore entirely hypothetical, unlikely to occur, and one we hope no president will ever have to confront. It is possible, I suppose, to imagine an extraordinary circumstance in which it would be necessary and appropriate under the Constitution and applicable laws of the United States for the president to authorize the military to use lethal force within the territory of the United States. For example, the president could conceivably have no choice but to authorize the military to use such force, if necessary, to protect the homeland in the circumstances of a catastrophic attack, like the ones suffered on December 7th, 1941 and September 11th, 2001. Were such an emergency to arise, I would examine the particular facts and circumstances before advising the President on the scope of his authority. Sincerely, Eric H. Holder, Jr., Attorney General. So it is good to have this letter as a response to Senator Paul's inquiry, and I believe that the inquiry Senator Paul raised is a legitimate one. It is also essential that we have some clarity with regard to the administration's position on this type of an attack. It is important for us to remember that every time government acts, it does so at the expense of the liberty of individual Americans. This doesn't mean that government action is bad. This simply means that government action always has to be weighed. It has to be counterbalanced against the impact that it has on the citizenry. It's very important that we approach these things delicately. Nowhere is this balancing act more necessary than where we have circumstances in which government action threatens not just the liberty, but also the property, or most importantly, the life of an individual American. Where life is threatened, the concerns of the Constitution are at their highest. Where life is threatened as a result of government action, government owes it to the citizens to undertake all of its activities with utmost caution. It owes it to its citizens never to deprive human beings of their lives, particularly American citizens, and unless it has done so through operation of law, with what we call due process of law. It is on this concept, due process of law, that the Fifth and 14th Amendments of our Constitution focus so intently. Due process of law is a familiar phrase to many Americans. We've heard this phrase over and over and over again. We understand on some level what it means, but I'd like to talk for a few minutes in response to Senator Paul's question about the fact that in order to have due process of law, you have to have a familiar legal standard, or at least a legal standard. You have to have a law that is capable of being applied in a way that American citizens can understand. They can read the law, they can review it, they can understand what the law requires of them. They can understand what it is that the law demands and what it is that the law authorizes the government to do. You see, because in the absence of such a law that can be applied, a law that can be understood in advance of its application, you run a very real risk of arbitrary and capricious government action, where government action is arbitrary and capricious and where it threatens to undermine life, liberty, or property, but especially life. You have the greatest level of concern, where the greatest level of detail must be examined with regard to what the government wants to do. So in this circumstance, where the question relates to whether, under what circumstances, to what extent, the government may take an American life, the government may snuff out the life of an individual American citizen, the government has an obligation to see to it and to assure its citizens that it won't ever undertake such an action without due process of law. And to have due process of law, you've got to have a discernible legal standard. A discernible legal standard is not entirely evident on the face of this letter. It's understandable. This is just a letter, a brief response to Senator Paul's inquiry. It is, however, a little bit troubling that Attorney General Eric Holder doesn't do more to assure Senator Paul in this response to his letter that these kinds of actions wouldn't be necessary to undertake on American soil, that these kinds of actions would be fraught with constitutional problems when undertaken on American soil. It's difficult to understand why the Attorney General wouldn't just say, we won't do this. This would be fraught with constitutional problems. This is not something we would do. Also troubling is the related point that the Attorney General has apparently relied on some legal analysis provided by the chief advisory body within the U.S. Department of Justice. The U.S. Department of Justice is something that one might loosely describe as the largest law firm in the United States. It is the law firm of the federal government. And within any law firm, you've got lawyers who do different things. You've got lawyers who specialize primarily in litigation. You've got lawyers who specialize primarily in drafting agreements or in giving advice to people. The Office of Legal Counsel within the U.S. Department of Justice is the chief advisory office within DOJ. It was the Office of Legal Counsel that drafted one or more memos outlining the circumstances in which the Obama administration might consider undertaking actions involving lethal force against American citizens. Sadly, most of us in the United States Senate have been unable to review those. The American people generally have been unable to review them. But it is particularly frustrating that those of us who are members of the Senate Judiciary Committee and therefore have an oversight responsibility over the U.S. Department of Justice have not been fortunate enough to review the memorandum upon which the Obama administration has apparently relied in undertaking this legal analysis. I had the opportunity to question, and did question this morning, Attorney General Eric Holder with regard to these memoranda, explaining to him the great need that we have to be able to review these memoranda, particularly as members of the Senate Judiciary Committee. I explained to them that this is part of our oversight responsibility, that this is our duty, it is our right to see such documents, and that it's very frustrating that we have not been allowed to see such documents. I added to that my concern that what we do have is a different document, not the Office of Legal Counsel memoranda, but instead something that is captioned simply as the Department of Justice white paper. I've always thought that was an interesting phrase, white paper. I don't know why they feel the need to call it that, why they don't just call it a paper. Normally we don't have legal analysis or other important documents that are written on green paper or orange paper or